Sujit.
Yes, sir.
Yes,
Yes,
sir.
sir.
Yes, sir.
Uh, First of all, I'm thankful to Honorable Chairman, Bar Council, Honorable Vice Chairman, also the Bar Council of India member for giving me this opportunity for organizing, first of all, this first type of a distant learning BLIC program, basic legal education program. And this is with a new concept which the Bar Council has adopted. That concept is to have the enrollment with this condition that 8 days CLIP program will be exercised by all the newly enrolled advocate in a 1 year time. The purpose behind this was with the previous experience of organizing CLIP program for last 13 years. And we found that the law students, when they are in a law college, some aspects of academics is always given to them. The law teachers are the full-time teachers. They are well in the academics. They can explain the academic part very well. However, as far as the practical aspect of the law is concerned, the law teacher perhaps are away from the practice because they are the full-time teachers. Previously, there was a type of the arrangement in the law colleges where the part-time lecturers, the practicing lawyers used to go as a part-time lecturer. But because of the new policy adopted by the UGC, this was abolished, and now the full-time professors are required there. So because of that, we always feel that there is a gap between the practical aspect of the law and the academic part of the law. And because of that, this particular difference of the approach, academical approach and the practical approach, these being totally different approaches, there is always the lack of the practical approach in the law students when they complete their degree. And therefore, it is a concern for the entire legal fraternity as such that how we should fill up this gap of this particular practical training to the law students during the law colleges. So there was a lot of you see schemes. First of all, there was a scheme designed by the Bar Council of India where during the fifth year of the pre-law course, even a pre-law course come out of the same concept that this particular practical approach can be given by giving them a full-time course of 5 years where all the social background, political background of the profession, the academic part of the profession, the other subjects of language, as now Sujit rightly said that the language is an important aspect. And if you are going to be lawyer and a practice going to be practice either in a civil side or in a criminal side, see friends, whatever language you may be adopting, you may have your mother language, but if you are practicing in a Maharashtra, the charge sheet is going to be in a Marathi. The charge sheet of any crime is going to be in Marathi, and therefore the FIR will be in Marathi, the charge sheet will be in Marathi. First part. Second part, if you are in the practice of the civil side and if you are dealing with the property, the revenue record is going to be in Marathi. You must understand what is 712 extract, what is mutation entry. So this language aspect is often important, and therefore you must be good in English also, because English is the official language as per the constitutional provision under Article 348. The official language of the court has been given. For a high court, it is English. As far as Maharashtra is concerned, it is not Marathi yet. The demand is there that even in a high court there should be some functioning in a Marathi. Why it is so? It's not a question of an ego of a language, but it's a question that the person who are represented in the courts of the law, they are the main litigants, they are the consumer of the justice. And it's a natural principle of a justice that whoever is tried, he must be tried in a language which is known to him. So if the litigant knows that language, then they should know it. And therefore, considering that in a state of Maharashtra, when there is a majority of the citizens, they are of they are of having a Marathi language as their mother tongue naturally. In our civil procedure code, it has been described. If you go to section 137, 138 of the CPC, you will find that there is arrangement that for this, except for the Mumbai, Mumbai provincial area, for all other area, the language of the court, that is of recording of the evidence, chief examination, cross examination, and all other things, they are in Marathi. And uh, others part of arguments and other things, they are in a English. That is optional. Even nowadays the arguments are going on in a Marathi also. So the friends, language is important. And therefore when we thought all this process, majority law students come from the rural area. They are having a difficulty with English words, the English language. Some of the students from the area like metro cities, Mumbai, Pune, Nagpur, Chana, they don't know Marathi, but they have to deal with the Marathi. So all these aspects should be practically tackled in law college itself, was the basic concept. And therefore the 5 years course of the pre-law course was designed for the law students. Then comes this practical aspect. Bar Council of India decided to have a practical training in a chambers for 1 year, right after completion of the fourth year. This aspect was again challenged in a Supreme Court. And a Supreme Court directed that giving an enrollment is the authority of a Bar Council of Maharashtra and Goa under Section 6 of the Advocate Act. Bar Council is a statutory authority created for regularizing the profession of the law. The concept of the establishment of a Bar Council is that, friends, there is a legislative body, there is a judiciary. You have learned the Constitution, that these are the independent organs of the Constitution: legislative body, law executing body, judiciary, the executive body, the government officers. These are the different organs of the Constitution. Here in judiciary, the law made by the lawmakers are interpreted, and laws are made for the society, law are executed for the society by the judiciary. In between there is a society, and this society, as far as judiciary is concerned, should be represented by the lawyers. You are not only an individual professional friend. Under the concept of the Advocate Act and even under the concept of the Constitution, you are representing the people at large as a law officers, and therefore you are given a status as a law officers. And therefore it becomes your responsibility to communicate to the lawmakers also and to the law executors also, that is the judiciary, what is the requirement of the society. This collective responsibility of the lawyer is to be functioned as per Advocate Act, or through the media of, or through the platform of the Bar Council. That is the basic concept of the Bar Council. And therefore we always say that Bar Council is the buffer agency between the lawmaking body and the law executing body. In between, we all lawyers together by elections, by electoral methods, elect our representatives. 25 representatives, 2 advocate generals are there, and in total these 27 peoples represent the Bar Council. So the basic concept by CLIP was that, by establishing a CLIP, was that the practical aspect which is not taught to the law student in the law colleges, that should be shared with them by an experienced person on a different process of the law. Taking this concept, we executed for last 13 years, and you can share this experience with all that participants who have been participated in the CLIP, either 1 day CLIP, 2 day CLIPs, or even a 4 days residential CLIP regularly, which are organized by the Bar Council at least for 7 to 8 times in a year at a different parts of the Maharashtra. There the law students who are the practicing lawyers also for 2 years, 3 years, 4 years, 7 years, 10 years, 15 years, even 20 years, they shared their views that this should be given to the new lawyers, because in the start of the profession, if whatever vision today we are getting, if this is given, this vision is shared with them, these new law students, they will be a better professionals. And therefore the theme of the bar council while organizing the clip program was that developing the skill of advocacy. To become a perfect advocate, he must have a proper knowledge of the law, he must have a proper appreciation of the current position of the law, the case laws, the authorities. Apart from that, he should have a correct reading of the society, because he must be a perfect person of the society, where you have to represent justice as a law officer. With this concept, we introduced this concept of the basic legal education program BLEP, with the concept that now the Bar Council has to shoulder this responsibility, that whatever lacuna is there in a legal education of not having a proper practical training, this practical training should be given by these new enrolled advocates by giving them 8 days clip. And that they only we decided that 4 days will be a physical attendance, where you will be called at one place in a different portions, 400 at a time, 300 at a time. You will stay together there for 2 days or 4 days, whatever the organization is possible. And 4 days we were already designing to have by through the distant learning, so that nobody should be bothered to again travel and spend your time and money for going undergoing this training program. Out of that, this blip has been organized, friends. And I'm sure the basis of the blip is that the basic procedure should be known to you. Evidence Act. And in an evidence, the basic procedure for civil and trial is to be conducted, the jurisprudence is of preponderance of the probability. And if a criminal trial is to be conducted, the jurisprudence is of presumption of innocence. And on the basis of this jurisprudence, the procedure is also used. The provisions of Evidence Act is also used, and the substantial law. It may be Indian Penal Code for a criminal trial. It may be any other criminal law for a criminal trial. It can be a Contract Act, Transfer of Property Act, Specific Relief Act, Hindu law, Muslim law, Persons law, for any purpose of the civil dispute. They will be interpreted by using the principle of preponderance of probability. And this particular civil trial, if you are going to tackle, you should understand what is the preponderance of the probability. It's not my today's subject, so I will not um, uh, take your time on explaining what is preponderance of the probability. Already our sir has given you the basic concept. And therefore, my today's subject is that introducing you to the subject of the Civil Procedure Code, CPC. My experience is that whenever I go for a lecture on a CPC, particularly, the young advocates, or it may be a senior advocates, this is that, oh, it's a long procedure. It's now going to be a boring thing. I will try to put a CPC in such a manner that you will feel that it's not so boring. It's also interesting. And the only approach for that purpose should be of a simple, logical thought for adopting a natural principle of justice. A natural principle of justice, whatever the principles are there, which are known to most of you, whether we are a lawyer, whether we are not a lawyer. The natural principle of justice are there in a mind, body, in a human of a human being as an inherent quality. For example, suppose a simple person, an uneducated one, simple person from a road is arrested or held up. He will ask you a question: what is my wrong? What exactly wrong is my, why you are arresting me? Why you are doing? He does not require the knowledge of the law. It's a human psychology. It's a natural instinct. Then the person, if he is authorized and doing a legal one, he'll explain you, explain him that this is your wrong. Like suppose a person want to file some complaint. Suppose you want to file a complaint that this X person unauthorizedly arrest me. He will go to the police station. But if he want to make some another complaint, I am not getting a 712 extract. He will go to the revenue authority. So, natural principle of justice, complaint is to be filed. It is to be filed to the competent authority. Once it is filed to the competent authority, the next step in a natural principle of justice, just imagine, keeping law aside, the complaint is filed against somebody. So the competent authority will issue notice to that third party that yes, XYZ, a complaint has been filed by this person against you. What is your say? So the notice will be issued. The notice will be received. It will be served. He will come. He will appear before the authority. He will appear and say, yes, give me copy. I will go through it. If he is not with copy, he will go through it and he will file his say. This particular sequence of filing a complaint to the competent authority, notice to be issued against the adverse person to be served, adverse person will appear, adverse person will file a say. Now the authority has a complaint before him and a say of an opposite party before him. Both the parties are before him. So the naturally the competent authority will see the contents of both the things, complaint and the say. And after going to these two things, the competent authority will ask that if any evidence is there to the complainant in support of this or to the opponent in support of this, that evidence will be taken, any document, any witness, whatever may be. And then both party will be heard and decision will be given. It's so simple, friends. This sequence of a natural principle of justice can be explained by any layman. It does not require the law graduation. It does not require the practice of the law. If these particular things are to be told as a procedure for conducting some judicial work, then it can be understood, it can be told, it can be followed by any layman person. You will be agree with me. You do not require this. Complaint, competent authority, service, appearance, say, evidence of the both parties, hearing to the both parties, and the decision. Simple thing. This simple logic of the natural principle of justice is incorporated in the civil procedure code in a same simple manner, in a same logical sequence, and therefore you did not bothered about the quantum, the sections and orders, because everything is designed in this particular sequence only. You have to keep in your mind what particular stage of the matter I am dealing with. I am dealing with filing of a complaint. Okay, plaint. If I am dealing with appearance as opposite party, yes, appearance of the defendant. If I am dealing with the service to the opponent party, yes, service of summons is there. If I am dealing with filing the complaint before the competent authority, yes, jurisdiction of the court is there, filing procedure is there. If I am talking about filing the say of the opposite party, then it is written statement of the defendant, nothing else. Then it's filing of the document. Yes, there is a filing of the document before the hearing. Then there is a hearing. There is evidence, slightly elaborated procedure for the evidence. And then there is argument and judgment. This is a sequence of the civil procedure code, friends. And then you have to just understood this particular sequence in a proper manner, how section deals with this sequence. how orders deal with the sequence. This is only to be understood for appreciating the logical sequence of the civil procedure code. Once you start understanding this logical sequence of the civil procedure code, I'm sure it's the simplest document. It's the simplest logical document. See, friends, civil trial or a criminal trial, it has two ends. Civil trial, it starts by filing of the plaint, okay, and it ends either by decree of the suit or by rejection of the suit. In these 2 points, there are different stages: one, two, three, four, five, six. And these stages are designed in such a logical manner in a civil procedure code that you can give an example of a railway track. Suppose you start from a VT station, CST, and you have to reach to Nagpur. Then the route is designed of the railway. That two rules, they design the route. And what is the route? You know, it starts from CST, it will come to Dadar, it will come to Thana, it will come to another Kasara, it will come to Nasik, it will go to Bhusawal, so and it will reach to the Nagpur. This is the procedure for traveling a train from CST to Nagpur. CPC is nothing less than these rules. This railway track, रेल्वेच्या गाडीचे रूळ थे, या रुळावर तुमची सिव्हिल ट्रायल चालली पाहिजे. युअर सिव्हिल ट्रायल मस्ट ट्रॅव्हल on this particular track. If you are not using a track, your trial is out of track and it is either collapse or it is thrown away. If you are not on a procedure, if you are doing something out of procedure, then friends, you are not on the track. So law expect that be on a track. If you are conducting a civil trial, use the track of the CPC. The stations are fixed. And that stations goes on like this only. Suit, pleading, filing, summons, written statement, appearance, so and so and so and so, so and so, up to the decree or rejection of the suit. Similar is the criminal trial also. CRPC works like this rule. The FIR is filed, the charge sheet is filed, the charge sheet is committed to the court, charge sheet has gone to the magistrate, the further procedure of admission of document is there, charge sheet is there, plea guilty is there, the conducting trial is there, evidence is there, witnesses are there, go on. It is a design track for the criminal trial, CRPC. Okay, so CPC is a track of the railway in which your civil trial is going to travel. This track should not be forgotten by the lawyer and even by the judge. First principle. Then who hold this train with the engine of that particular train? Evidence Act is the engine of that particular train, and all other part of the law, substantial parts of the law, Contract Act, the Transfer of Property Act, everything, they are there with the train. But engine is of Evidence Act. Without evidence, you can't go ahead. You can't take your cause ahead. And without CPC, you can't travel, friends. So the CPC works like a train track, railway track for conducting a civil trial. Now, with this first understanding or introductory part of the Civil Procedure Code, let me invite you to look carefully towards the title of the law. What is the title of the law? Civil Procedure Code. Okay, it is a Civil Procedure Code. The lawyer should always have a doubtful mind. First, the doubt should be there in the mind of the lawyer that why code is used, CODE, code. Why it is not act? Evidence is an evidence act. And why it is not a civil procedure act? Why it is code? Why it is Criminal Procedure Code, why the Indian Penal Code, why Contract Act, why Transfer of Property Act, why Prevention of Corruption Act, why Negotiable of Instrument Act. What is the difference between an act and the code? This question should rise in the mind of the lawyer. Now it's something away more than a layman. Layman can understand that natural principle of justice sequence of that. He knows that. But the code and act are the words. Normal layman will feel that it is something law. I don't have to bother, it is something law. But a lawyer and a judge should not keep that mind. He always try to find out. My own experience I must share you. I practiced for last 34 years, particularly on a civil side, as on a civil trial. I like civil trials. And when this academic aspect of the civil procedure I thought, or I start learning, or I start looking towards it after 15 years back, after completing perhaps 20 years of practice, this question was not in my mind. Why it is act? And then one day when I started, I asked this question to myself: the why it is act, why it is code, and why it is not an act. After 20 years of practice, friends, and I'm sharing you with you now, just with your 3 months or 4 months practice. That is the benefit of the blip for we all of us. I could not get that blip. Otherwise, should have not waited for 20 years for understand why code is used and why not act is used. When these questions arise and it is related to the words, the first important rule of interpretation: find out the correct dictionary meaning of the word. So, with that rule, I try to find out what is the correct meaning of the word code, CODE, code. And I went to the dictionary. You should go to the dictionary, friends. You must have a mobile in your hand. So now we are not in a normal classroom. I always wait here and ask this our participant friends, colleagues, to find out the dictionary meaning of the word code. You will find that there is a particular meaning. It is not a single document, friend. Code does not include single document. It's a collection of the document. If I have to tell in the Marathi, it is called as a Sangraha code. Sangraha. So it is a Sangraha. It is a collection of a different document. If it is act, it is a single document. It doesn't have anything attached to that particular document of an act. If act is there and rules are to be framed, there is rule making power in the act itself. You can go to any act. You can take the Town Planning Act, Regional Town Planning Act. You will find that there is a rule making power, and by using that rule making power, rules are framed. So many rules are framed. 8, 10 different types of rules are framed. Development control rules, building plan rules, layout rules. So many rules are there. They are different documents. They are not a part of the Regional Town Planning Act. So, rules, acts, act is the main body, and the rules are the wheels, small wheels of the acts. By use of these wheels of the rules, act travels, act is used. That is the purpose for which the rules are made. Rules are for the consequential development of the statutory provisions. That is the different document. But if you see the civil procedure code, friends, civil procedure code contains section in the first part. From section 1 to section 158, it is the first part. Then what is order? How order is connected to the sections? You can go to section 121 and you will find that it is described that there will be now schedule 1 to these sections. In this schedule 1, there will be rules. and that rules will be part and parcel of this code. So here the concept of act is elaborated, a statutory provision, that is sections from 1 to 58. They are attached by Schedule 1, and that Schedule 1 is rules. That rules are orders from Order 1 to Order 51. Having different rules. How many rules? I don't know. I have written 3 books on a civil procedure code. Still, if you ask me how many rules exactly, I don't know. Maybe 500, maybe 600, maybe 800. Whatever rules are there, but rules are there. So this Schedule 1 is a part and parcel of the sections now. So first part section, second part rules. Is it the end of the civil procedure code? I will just request my all friends, participants, new lawyers to open your civil procedure code and just see the index of the civil procedure code. And you will find there, because index is the first guidance on that particular subject. The index shows you how the subject is defined, how the subject has been divided, how many parts are there, each part having how many sections are there, because each part relates to particular topic, and the sections under that topics are to be interpreted in light of the meaning of this topic. Summons, Order 5, then all provisions of the Order 5 are to be interpreted for the purpose of summons only and not for any other purpose. So this is the design in which the acts and the statutes are made. So you will find that after section and after order, it is not an end of the civil procedure code, friends. There is appendix A to H. And this appendix A to H gives you different formats. In our times, we used to law by using a famous guide of Zabwala. I don't know nowadays you use or not, but we use Zabwala. Gadge sir will agree with me that we used to go through Zabwala. And Zabwala, because it was designed in such a simple manner, such a understanding manner, that we were happy. In a short time, we used to understand the subject. The basic requirement, though the elaborate aspect was not understood, basic things was understood. So many times it is understood that what is this appendix A? It is just a guide. What is there? If you see appendix A, you will find that there are different forms of pleading given. Pleading means both suits as well as written statement. They are given in this particular appendix A. But it is a part of the code. So what is the use of that particular formats given in that appendix A for preparation of particular types of suit? Which types of suit? Many types of suits. Whatever you are dealing with, it may be money lending suit, it may be specific relief act, it may be partition suit, it may be foreclosure suit, it may be declaration suit, it may be injunction suit. All suits are covered there, and you will find out a short prescribed format of the pleading and with numbers. And what is the use? What is the compulsion? Whether it is a guide like Zabwala, that okay, try to do a pleading for the particular suit like this. For that purpose, to impress you that this is a part of the code, appendix A, and it is therefore obligatory. It's not a guiding only. Whenever you are designing a particular type of a suit, you have to follow that form. And that minimum pleading which are given in that particular format must appear in your suit. If that pleadings are not appearing in your pleadings, which are given in a particular format, and you are bypassing that pleading, the effect will be that your suit and your pleading will be challenged on the ground of improper pleading. And you will have to face the consequences of that. So as a lawyer now, your responsibility, you are there to formulate the facts given by the client in a legal form. You have to write a plaint, and you are not writing an essay when you are writing a plaint. You are bound by CPC. The rules are there. The orders are there, the formats are there. You have to follow it. Just to impress you on this necessity to understood these pleadings, I will refer two forms. One form is form number 46 and another is 47. Okay, both forms you can just take whenever you will be comfortable and just go through that particular formats. These are the forms for preparation of the plaint in a suit of specific relief act. You know, normally the lawyer or even a layman knows that whenever suit of the specific performance is to be pleaded, one has to write that plaintiff is ready and willing to perform his part of a contract. This is required to be pleaded. If this is not required to be pleaded and it is not pleaded, the suit will be rejected. There are two reasons. First reason is that Specific Relief Act under Section 16, a suit of a Specific Relief Act is to be claimed. And in that Section 16, there is a provision that whoever wants to make a specific performance relief, he must plead and prove that he was ready and willing to perform his part of a contract. This much pleading must appear there. This is there in number 46. So the reasons are two, because Specific Relief Act say and form number 46 say that these pleadings are there, it must be there. Apart from that, you will find that there is another two lines in this form. Plaintiff has applied to defendant for completing specific relief, specific performance, but defendant has not complied. This is also the one of the line given in the necessary pleading. Plaintiff has applied to defendant, but the defendant has not complied for specific performance. Now, these lines are occasionally written in a pleading. Even senior lawyers, when we had a discussion on this particular use of the appendix in a senior bars also, they argued that this is not required. What will be the fate? You are the generation who knows who are well acquainted with the case laws. What is the Supreme Court view and what is the High Court view? You can go and immediately have the appreciation of the law on this particular aspect. You just go and make research in a suit for a specific relief act. If a form number 46 and 47 not followed, or the pleadings given in that particular formats are not followed, what will be the effect? And you will find that the effect is of a rejection of the suit. So meaning that Appendix A, whatever the formats are there, that mandatory part of the pleading must appear in the plaint or even in the written statement to be written by the lawyer. And suppose you are not using these words which are given in the forms, which is a requirement of the law as per the Specific Relief Act or even as per the forms of the Appendix A, then what is the responsibility of the lawyer? Are you escaped from the responsibility? Suppose the suit dismisses, the suit for a specific relief dismissed because there was no proper pleading. You did not pleaded that the plaintiff was ready and willing to perform his part of contract, or the plaintiff has applied to the defendant as it is mandated in the form number 46 and 47. In that particular case, your suit will be rejected and you will be responsible for the client. You will be perhaps liable for the action also, because it's a professional responsibility. It is not a responsibility of the client to make this type of a pleading. He has handed you a brief. He has given you a facts. He has given you a stamp duty. He has given you your fees, and whether fees are given or not given. Once the wakalatnama is signed, your obligation starts to fulfill all legal formalities required for the law, whether it is in a limitation, whether proper court fee is there, whether proper jurisdiction is there, whether proper pleading is there, whether proper process fee is there, whether summons is served, whether the report is taken, all the procedures and the legal formalities, the responsibility is reposed on the shoulder of the lawyer. Now you are a recognized agent, a recognized agent as defined in CPC in order 3, and therefore as a recognized agent you are responsible for the results. So if you fail on this any technical grounds, friends, perhaps I'm afraid you must be aware, and just I'm giving you that particular vision that you must be aware that this is your professional responsibility. So Appendix A is part of the Civil Procedure Code. So in totality, the friends, the Civil Procedure Code includes sections, orders, appendix. Appendix B, C, D, E, F, there are different formats. The formats for the summons also, the format for the process also, the formats for notice to admit, the formats for notice to produce. All these formats are there in the Civil Procedure Code. And this particularly in Appendix A. All these formats are there, friends. So only the responsibility of the lawyer is to understood the document. And when you go for the Civil Procedure Code, you must understood that this is not only the document relating to sections, orders also, it is also the document relating to the appendix also. So this is a broad concept of the Civil Procedure Code, which you must keep in your mind that this is an act also, this is the rules also, and this is the appendix formats also, friends. So with this, you should be prepare yourself. And therefore, my first request to all the participants will be that, friends, take the advantage of this vacation. Start reading Civil Procedure Code right from section 1 to section 158. Stop there. Again, start from order 1, rules whatever there are, order 51. Then go to the appendix A to H. This is the time if you go for this exercise, friends, in this particular lockdown time. Perhaps in other times, nobody gets such a comfortable time. Everybody is busy, whether he's a junior, whether he's a senior, he has his own engagement. But this lockdown time perhaps has created a problem, but has given a lot of opportunity, particularly for the lawyer to interact and to give a thinking whether my proper thinking is there, whether my exercise is proper, whether I am doing a proper work. This particular analysis must be done by the lawyer, all junior or senior, everybody. And I'm sure that you will get a different vision to work. Similarly, you should go through with the CRPC and Evidence Act. Minimum these 3 documents. You should try to read. Just bare act. Don't go for a commentary, friends. The bare acts are such strong documents that hardly you will require any commentary, hardly you will require any case laws on these particular topics. And therefore, as far as CPC is concerned, my request will be that right from sections, orders, and appendix, read it completely. This is the basic code, संग्रह. या सगळ्यांचा मिळून हा संग्रह आहे. आणि म्हणून त्याला कोड म्हटलेला आहे. म्हणून त्याला ऍक्ट नाही म्हटलेलं. This is a difference, friends, between the other document and the Civil Procedure Code. This is also not the end. There are another additions to this document also. I'll just briefly mention here and I'll explain afterwards in the last phase of the judgment. And there are High Court amendments to the document of the Civil Procedure Code. 2 types of High Court amendments are there. High Court amendment and state amendments. State government is empowered to make certain amendments in this procedure. They are made. There are certain state amendments to Civil Procedure Code. What are these state amendments? What are that effects? We'll discuss afterwards. There is a power given to Honorable Bombay High Court to make certain amendments in certain provisions of the orders, particularly rules. And that power is there from order 131 to 121 to 135 of the Civil Procedure Code, where High Court is empowered to make such rules. And accordingly, High Court has made Bombay High Court amendments to the Civil Procedure Code. So 2 things. Maharashtra State Amendment is there. Bombay High Court amendments are there. With these 2 amendments, The fourth part of the document, CPC, is also to be understood. So this together gives you a complete picture of the civil procedure code. This procedure of the CPC is elaborately explained with another independent document. It's not a part of the CPC, but it's an independent document. That independent document is called as a civil manual. And the lawyer must read civil manual. The lawyer must read the criminal manual. Everywhere, if you are dealing with the land acquisition matters, our senior friend Mr. Annarao Patil is there. He knows for different manual for the land acquisition purposes is there. And these manuals are very useful. They are very in detail. For example, commissioner is to be appointed. Order 26 deal with that particular aspect. Section also deal with that particular aspect. But in a manual, a detail is given. Who is to be appointed as a commissioner? How notice is to be given? What format of a notice is to be there? What time is to be observed? How the record is to be done? How the report is to be given? How the maps are to be prepared? Everything. Such a detailed things. And if you know the civil manual, it is useful for doing that all activity. More useful when you go for a cross-examination, if you are going for a cross-examination of the commissioner. And if you know the details of the civil manual, and just by taking one of the details, if you go on asking, तुम्ही हे केलं का? तुम्ही त्याला अशी नोटीस दिली का? तुम्ही त्याला इतक्या वेळची नोटीस दिली का? तुम्ही त्याचा रिपोर्ट किती दिवसात दिला? तो तुम्ही 14 दिवसात का नाही दिला? काय कारण घडलं? विलंब झाला, त्याच्याबद्दल तुम्ही कळवलं का? वगैरे वगैरे वगैरे. So your cross examination is very effective, friends. Nobody can object you. If anybody object, you have to just open the manual and show to the court. See, it's your duty. In fact, Honorable Court, it's your guidance. Civil manual is mainly made for guidance of the judge. You might come across a question of exhibiting a document. दस्तऐवजाला निशाणी नंबर देणे म्हणजे फार मोठं काम असतं वकिलाचं. तुम्ही आता प्रॅक्टिसमध्ये तलवार घेऊन उतरलात की तुम्हाला पहिली लढाई कशाला करावी लागेल, तर डॉक्युमेंट दाखल करता येतात का आणि डॉक्युमेंटला निशाणी नंबर देता येतो का? बरोबर ना गाडगे साहेब? हा आपल्या वकिलीमधला अत्यंत महत्वाचा प्रश्न असतो. त्यामध्ये एक्झिबिट द्यायचं म्हणजे काय करायचा? डॉक्युमेंट आला ओरिजिनल का देऊन टाकायचा का एक्झिबिट कोर्टाने? मग द्यायचं तर काय लिहायचा? कोणी लिहायचा? कोणत्या शाईने लिहायचा? शिक्का मारायचा, नाही मारायचा, वर मारायचा, खाली मारायचा, त्याचा उल्लेख रोजनाम्यात करायचा, नाही करायचा, हे सगळे प्रोसिजर आहे. ते सगळं प्रोसिजर जे काय आहे ते त्या सिव्हिल मॅन्युअल मध्ये 2 पानं दिलेलं आहे. एक्झिबिट करायचा असेल त्याच्यात बसवा. एक्झिबिटला अपोज करायचा असेल त्याच्यातले जे लॅकून आहेत ते दाखवा. No court can say no to you because it's a guidance to the court. And you have to say to the court that this has to be followed by you. There is no original. Why you are giving an exhibit? There may be Xerox. There is no application for the secondary evidence. Why you are doing this? You can ask many questions. So for that purpose, friends, civil manual is a very important document. And therefore, I will again request you that use CPC. I'm not making you compulsory, friends. Don't take that as a compulsion, anything compulsion. So my elderly advice to you, good time for you. You will enjoy. If you have a friends, select 4 or 5 friends, divide the CPC topics. Even in a lockdown, use the Zoom or any other platform and start reading one after one the provision, term by term. You will enjoy, friends. I'm sure. I'm ready to have this exercise with you. Go on reading the provisions of the Civil Procedure Code. Go on reading the provisions of the civil manuals. Go on reading the provisions of the Evidence Act. Go on reading the provisions of the CRPC. Your another 3 years juniorship work, which you will do in a regular manner. 10:30 वाजता कोर्टात गेले, 5:30 वाजता परत आले, मग आपण आपल्या काही एन्जॉयमेंटला गेलो, हे करताना, कोर्टातलं काम करताना जे काही शिकायला मिळेल किंवा शिकाल ते पुढच्या 3 वर्षात त्याच्या इतक्याच क्षमतेचं सेम कॅपॅसिटी ऑफ द वर्क you can do in this long term time by giving 3 days to CPC, 3 days to civil manual. 6 days are sufficient. If you spare 4 hours per day, and that too by rotation, half hour by one, half hour by another, half hour by another, you just do this exercise, friends. And see, doing such exercise, don't consider as below standards. I still remember when I was of a practice of 15 years, Honorable Justice Dilip Bhosle, he was a chairman of a bar council, and he came to Nasik. At that time, I was having my own office. My father was a lawyer, my own office of 25 lawyers. Everything was there. I'm from a Marathi medium. I'm not from an English medium. And I started talking in a English fluently only after entering into a bar. Before that, जसा मराठी मुलं इकडे तिकडे हिचकिच करता, I was also in the same manner doing that. Nothing wrong because the mother tongue is there. I was not educated in English, but I was well with Marathi, so I can do a proper drafting of Satekar. I can do a proper drafting of the Khridikar. So people started paying me in a very initial, apart from the father's practice. So I could do that because I was knowing Marathi. I can read 712 extract. I can read the FIR copy. So I was able to appear in remand matters. In this entire process, friends, Justice Dilip Bhosle gives us one exercise when he came as a chairman, and he was having an affiliation for the rural area boys. He said that only do one exercise, particularly those who are having some sort of reservations for the English language in a profession. Select any 2 judgments, not more than 5 pages. Any judgments of the Bombay High Court, and do one exercise. Start your tape recorder, sit before tape recorder, go on reading that particular judgment continuously as it is, without waiting, you may be wrong, go on. आणि असं त्यांनी मला सांगितलं, सगळ्यांना म्हणजे आम्हाला 5 वेळा 5-6 वेळा जजमेंट तुम्ही वाचा. 5-6 वेळा वाचल्यानंतर 6व्या वेळेचं जे काय तुमचं जजमेंट आहे आणि पहिल्या वेळेचं जजमेंट आहे रीडिंग, ते तुम्ही बघा, तुम्हाला फरक जाणवेल. आम्हाला फरक जाणवला. And he said that go on continuing and have a habit that at least in a week, twice I will read 2 judgments in English, not just in a mind, openly, मोठ्याने बोलून, इंग्लिशमध्ये बोलून ते जजमेंट वाचायचे. You may be from an English convent school, friends. You must be conversant with the legal language. What is the terminology used in that particular judgment in context to that particular facts? That must be used. I was dealing with the Tenancy Act, Tenancy Law, and the word was that, तुम्हाला माहिती आहे कुळ कायदा नावाचा एक कायदा आपल्याकडे आहे. 1/457 ला जो जमीन कसत होता त्याच्या मालकीची जमीन झाली. And the word in a judgment was that by operation of a statute, the ownership was transferred and all the tenant becomes the owner. This cannot be understood. Otherwise, I had an entire connection of the facts. And I understood that by operation of a statute, म्हणजे कुळ कायदा 1/457 ला अंमलात आला. It came into operation on 1/4/1957. On that particular day, because of the operation of the law, as the law started operating, it came into existence. The property transferred from landlord to the tenant, and tenant become automatically owner by operation of the statute. This particular aspect was known to us only because we started with this habit. So I still continue that. I still remember that such schemes are to be given by the Bar Council. That was a contribution of a Bar Council in my own personal life. So this is always possible. And therefore, when I am talking about this exercise of reading CPC in sections, orders, appendix, manual, try to understand that it's had some meaning. You will find when you will complete the reading, you will find that you have a different vision on the proceedings. You have a different vision of a civil trial. Similarly, you can do an exercise for the CRPC and the Evidence Act also. So, friends, this was first of all a part of the Civil Procedure Code and its introductory part. Now, coming to the logical sequence and the provisions of the law, I'll come to it because today my aim is that not to explain you all section 1 to 158 and order 1 to 51 orders. We'll do that. We will have a course of 8 days lectures, and one by one we can do that. If you agree, it's not possible in this distant learning type of program. It is always possible, or otherwise also it is possible. Even your senior members of the bar will do that. But today my aim is to put out to give you a bird eye view of the design of the Civil Procedure Code, its use, and how the knowledge of walking on this route can be achieved by the lawyer. That is only. Today I can't give you an entire knowledge in a 2 hours time. Nobody should expect that. Neither it is expected. Still, I am not having a complete knowledge of the CPC. I had a very little knowledge of the CPC. And therefore, but I had a vision. If a particular problem comes, under which topic I have to search, under which section I have to make a research, or at least in which part of the CPC I have to make a research, that I can understand. And therefore, still today, the different issues comes. I will explain in the course of argument, in the course of my speech, how the issues comes practically and how we have to deal with them. So today my aim is to give you this vision as a newcomers in the profession, how your vision should be there. Friends, this particular suit, civil suit, is the main subject matter of the CPC. CPC is there for dealing the various stages of the suit. And as I told, this suit has its fixed stages. As we in the initial we discussed that if a train starts from a CST and reaches to Nagpur, it has its specific destinations, stations. Similarly, suit starts with the pleading. Pleading means plaint and written statement. With that pleading, suit starts. In fact, suit starts with plaint. It is a plaint is to be filed to the competent court having jurisdiction. That competent court has to issue a notice in a form of summons after payment of a process by the plaintiff, not before that. It's your lawyer's responsibility. The process is to be paid after filing of the suit. Not that only you have paid the stamp duty and your responsibility is over. After the filing of the suit, after the issuance of the notice ordered by the court, you have to pay the stamp duty, not before that. Then the court will issue a summons. Then summons are to be served in a provisions or in the procedure given from section 28, 27, 28, 29, 31 of the CPC, read with order 5. The summons are to be served. Then, after the service of the summons only, not before that. If summons is served, then only the obligation on the defendant starts to appear before the court. So the next stage is the appearance of the defendant. And on that appearance, there are various consequences. After service of summons, he did not appear, ex parte order will be there. He appears but did not file a written statement, no WS stage will be there. Then the further written statement, filing of the written statement, filing of the counterclaim, if anything is there, filing of the set-off, if anything is there. This is the first part of the suit. So we started from a plaint and we came up to the written statement. For that purpose, I had prepared one chart to show you the different stages of this suit. And I will request our moderator, coordinator, Sri Advocate Sujit. to kindly display that first chart number 1 which I have given you.
Ganesh Power sir, please do that.
Chart 1 is there, so I'll explain that chart to uh, participants. This is chart 4. Please go to chart 1. Yes. See friends now. I think it's small, but in the first part of the suit is the plaint and the plaintiff. Plaint and the plaintiff.
Sir, it's proper now?
Yeah, is proper. Plaint and the plaintiff, and the provisions which deals with plaintiff, these particular provisions which are given in the brackets. I will ask to share these charts to you. Perhaps the chart is not that way clearly. I think in a proper size is there. So first part of the entire suit proceeding is the plaintiff and the plaint. Second is the written statement and the defendant. When I talk about the plaint, it means that what should be the plaint, how the pleadings of the plaint should be there, what it should incorporate, and how it should be designed. What is the requirement, necessary requirements such as a verification, signature, etc. For a plaintiff, all these provisions will explain who can be a plaintiff, who cannot be a plaintiff, whether plaintiff can be a single, it can be in a representative form. All these details are there under this particular provision. So this is the first part. We'll come to that. Second, written statement. How written statement is to be filed, when it is to be filed, and who are the defendants, who can be defendants. This can be the second stage of the entire suit proceedings. In between, after this plain written statement, defendant, the stage come injunction, interim orders, which are the soul of our advocacy. Particularly in the junior times, you get an injunction, you will retain the client. If you don't get an injunction, perhaps the client may think otherwise, that I have to move to another court. So just like a bail in a criminal matter, injunction is there. And therefore, this particular stage of an interim orders in a form of an injunction, attachment, receiver, they are important, friends. Then comes the another stage, and that is the issues, different types of an issues. Just go upward slightly, if possible, Ganesh. And therefore, the issues is another stage. Then there is a hearing and judgment. Then there is a execution. Then there is a appeal and revision. Then there are certain supplementary provisions, special types of suits are there, and some miscellaneous provisions are there. So this particular first format gives you a broad distribution of the provision, how the particular provisions are made. And with certain guidelines are there, you can go through that. I'm not taking your time. So let us go to chart number 2 now. Chart number 2, please, Ganeshji. Yes, chart number 2. See here now. The CPC, which includes section, order, and appendix. Here you can see the title, section, order, and appendix in a CPC, how they are distributed, how they are applicable at different stages of the suit. So first, if you see suit in general, what is the jurisdiction, what is res judicata, what is the place of suing, when the transfers and withdrawals are possible. Section 9 to 26 of first part deals with these types of a provision. If you go to the orders here, and in order, suit, filing, everything is covered from order 1 to 4. So first part, in order 1, who are the parties? In order 2, 3, the recognized agent, place of suing. In order 4 also the jurisdiction, all these provisions are there. Then you come to the second stage. Once the suit is filed to the court in a proper jurisdiction, at proper place, then the second stage, which comes before the uh, uh, to be faced, is of a summons. Summons is to be issued. Here, Summons you have to see into two angles. First, payment of a process is also mandatory. And for that purpose, you can see here in part 1 only, section 27, 29, 31, 32 deals with summons. Whereas in an order 5, rule 1 to 30, they deals with a summons. Once this summons is completed, friends, then the another stage is of the uh, return statement, discovery, there the then the judgment, and the another part of the suit where the entire part of the sequence of the sections and orders I have prepared, and you can have this comparison in your mind. While doing this comparison, also try to connect this with the formats which are there in an appendix, which I have not written here. You find out that formats and you will get it. So this is chart number 2, which shows a broad distribution of this entire provisions of the CPC, which should be in your mind. Then to chart number 3, broadly, the suit is divided into 6 categories, which I have given in chart number 3. Kanishji, kindly take chart number 3 now, if possible. Yes, chart number 3. See, suit in general, summons, the sections and orders I have given, summons, then discovery and inspection, written statement, compromise, amendments, interim relief, interest, cost, etc. These are the 6 broad stages in which the suit is divided. So let us go to the 4th chart. You take these charts from Ganeshji. You kindly share these charts to all of them so that they can study it properly and they can have a link, because we can't go by every provisions and showing a link. It will take too time and it will be boring thing. You just go on that. We'll discuss the broad principle of the procedure. So come to last for chart number 4.
So the charts have been shared in the official WhatsApp group.
Sure, no, it's all right, good. Then just I will explain them the chart number 4 now. Yes. Now here now I have also given you the useful appendix which you can use. For example, suit, pleading, plaint, written statement, section 9 to 15 deals with this topic. Order 1, 6, 7, 8, they deals with this particular pleadings, plaint and written statement. And also appendix A deals with the pleadings, the forms of the pleading. So by using these provisions, order 1, order 6, order 7, read with section 9 to 15 and appendix A, you can prepare your topic of pleading, return, plaint, return statement. This also the counterclaim. When I will give you details of the pleading, we'll discuss that. Then second part, form of the suit, parties, frame, pleaders. All these provisions are there in order 1, also appendix A, and order 3 also, who is the recognized user agent, like advocate. All that details are there, and you can use this provision for the purpose of these particular topics. Then institution of the suit. Institution of the suit, section 15 to 26 deals with that. And order 1 to 4 also deals with that. By using this particular provision, you can well acquaint yourself with these topics of jurisdiction, place, transfer, res judicata. Okay. Then the summons, just take above the summons 27, 29, 31, 32, read with order 5, rule 1 to 30. Appendix B. Appendix B is the form of the summons. Here, for your younger generation, my suggestion is that whenever you are filing a suit, complete your suit along with the plaint, the documents, and also these formats of the summons. Many softwares, these appendix B formats are already now inbuilt there. And once you put your name of a plaintiff and a defendant, rest of all things are completed in that software. And whenever you are filing the suit in the court, file that along with the summons, so that the further time taken by the ministerial work to prepare the summons and then to make the issuance thereof, the major time is curtailed and you can use it. And therefore, for that purpose, the formats given in an appendix B, they are important, friends. Then come to an appearance of a defendant after the service of the summons. Order 9, deal with that. And in that particular purpose, in that particular order, all these types of things, that if you are not appear, what will be the order? If a suit is dismissed, then what is the remedy? You can make a restoration of the suit, you can make a reappearance in the suit. Everything is there in order 9. So appearance related everything you can find in order 9 and the provision there. Then written statement, counterclaim. Order 8 deals with this particular types of all subjects: written statement, counterclaim, and then the written statement to counterclaim, a set of everything is there in this order 8, and you can follow the provisions of order 8 for that particular purpose. Then important aspect of the amendment. So order 6, rule 17 deals with the amendment, and we will separately talk on this issue of amendment because it repeatedly comes before you. Then interim relief. See orders 90, section 94, 95, 151, read with order 36 to 40. They deal with this interim relief. It may be an interim injunction, it may be some attachment of the property, it may be appointment of the receiver, anything which is an interim relief before the decree and a judgment, either the plaintiff or the defendant, he has to claim this particular provision of 94, 95, 151, and from order 36 to 40, you can deal with. Then there is a important nowadays current era's provision, that is the ADR mechanism, settlement out of ADR mechanism. Section 89 is the important section which deal mainly about this ADR. What is ADR? You know, arbitration, conciliation, mediation, lok adalat, judicial settlement. 5 types of an ADR are recognized by the Civil Procedure Code. Out of that, anyone can be adopted by going to section 89 or order 10A of the Civil Procedure Code. Then this is the important part of discovery and inspection, about which I'm going to explain you. This particular topic covers the notice to admit a particular fact, notice to admit a particular document, notice to produce the document, interrogatories, inspection of the document, appointment of the commissioner. These all provisions will be covered here, and you will find that from section 30 and from order 11 to 13, along with appendix C, these all discovery aspect can be covered. This is a subject, or this is the stage of the suit, friends. If it is properly mastered by the advocate, you can substantially reduce the length of the litigation by using all these provisions. It is just like a FIR is filed. Once FIR is filed, investigation starts and charge sheet is prepared. In between, the police officer collects the document, makes the statements, and then the every material is collected. Whatever evidence is collected, it is submitted in a charge sheet to the court. A similar type of a remedy is available to the party. Here, no investigation machinery, independent investigation machinery is there. But this particular stage gives you power to do all these types of an exercise. And this particular exercise is available easily for the advocate if you just follow these provisions. Whatever the provisions are there, they are in detail, and one should follow that. Then there is a withdrawal and compromise. Withdrawal and compromise is also one of the important stage. It should be done in a proper particular procedure only. If it is not done, suppose a suit is withdrawn, and if that withdrawal is without the permission of the court, the plaintiff is barred to file another suit, because there is such a provision in order 23 rule 1, which says that if a suit is withdrawn without leave of the court, then the plaintiff will be precluded from filing fresh suit. If you have to take the permission of the court in that particular aspect, you have to make out a case. The court will only see the case is proper, and leave will be admitted, or leave will not be admitted. If a leave to withdraw is not accepted by the court, your suit will remain. If court is withdrawing without leave, that will be illegal, and you can again challenge it, and you can get it set aside. The court will either give a leave and withdraw, or court will reject the leave and keep the suit as it is. This is a requirement of Order 23, and therefore this withdrawal is important. The compromise is also important. Say, friends, once a compromise is done now, that compromise cannot be challenged in a subsequent suit on a ground that the compromise was legal, invalid, against law. Because under Order 23, Rule 3A is there. And under Rule 3A now, there is a mandatory amended provision which says that because the compromise is legal, on any legal or illegal, or valid or invalid, you can't file another fresh suit. Now, then what will the remedy? That is a big question of discussion. I'm not putting before you at this stage. You will find it something complicated, and I don't want to make a subject complicated for you. So this is a subject with stage withdrawal, which is there, which also includes the compromise also. Then issues are there. Order 10 and 14 at two stages issues are to be framed. That I will come to you in a detail. And then hearing stages are there. Witnesses are to be called. Production of document at the time of a hearing is possible. Adjournment is possible, but reasonably. If you are taking an unreasonable adjournment, basically you will be going against the policy that we have to march towards a speedy justice now. Basically, speedy justice is a fundamental right of the litigant recognized under Article 21. You can go through that judgment. So if you are making an unwanted adjournments, then that activity of an advocate, even nowadays, is called as a misconduct of the advocate. And therefore, for that adjournment, you have to be very cautious. And my appeal will be that don't go for adjournment. Be ready whenever your study is completed. So affidavit is there, and hearing of matter is there, judgment and decree. So these are the comparative charts before you, and that comparative chart gives you how the sections are connected to the orders, how orders are connected to the Appendix C. So initial part, when I told you that Civil Procedure Code means sections, orders, and Appendix C, they are interconnected to each others. And not only that, now further, when I talk about the civil manual, this civil manual is also connected with all these stages. And that particular distribution I'm not putting before you because it will take a long time. But you can compare yourself by going through the civil manual. And in that manual, you will find that all these stages, in part 6, we have divided this particular CPC into the sections, orders, and Appendix C. And in this all sections, civil manual gives you a detailed procedure for conducting the civil trial. So friends, now thank you Ganeshji for showing this chart. Now the purpose of chart is over. Now we can go to the main theoretical aspects of some of the basic concepts of the CPC. Civil suit stands on the footing of pleading. Pleading is the foundation of the civil suit. Whatever is pleaded, evidence can be given only of that particular facts which are pleaded. The facts which are not pleaded, no evidence can be given. Gadge Sahib, I'm right in an evidence. The major objection comes from opposite sides. Correct? Varun Jigar sir, you are also there. The major objection comes from opposite side that it is not pleaded. And either you are on a plaintiff side or you are on a defendant side. If you are on a defendant side, and when plaintiff starts evidence, you have to be very keen and cautious about the pleading. The defendant should see what is pleaded in a plaint. And if the evidence of the plaintiff exceeds that pleading, the defendant should object that this is not a pleaded part and it should be objected. Similarly, when defendant starts his evidence, the plaintiff must be cautious about the written statement, the contentions in the written statement. And that particular aspects of the pleading in a written statement, which is not pleaded, cannot be taken in an evidence. He can object that. And straight away it will be thrown away of the evidence. The fact which is not pleaded cannot be an evidence. Whatever it may be with support of some document, some witnesses. If it is not pleaded, it is not a part of the entire game of the suit. It is to be just thrown away without giving any consideration. So when we talk about the pleading, friends, and when we talk about not pleaded things, one thing should be remembered. The basic rule of the pleading is that pleading must be precise and perfect. It is not expected that the pleading should be of 50 pages, 100 pages. Law and facts are not to be pleaded. If you, in a suit of a specific performance, want to say that you are ready and willing to perform your part of contract, your pleading should be to this extent. मी वादी प्रतिवादीला ठरलेली कराराची किंमत देण्यास सदैव तयार व उत्सुक होतो. तयार व उत्सुक होतो किंवा तयार आणि उत्सुक होतो. The word used is ready and or nay, and that spirit must be reflected in your pleading. मग ते कसं तयार होतो? मग मी कोणत्या बँकेत पैसे ठेवले होते, मग माझे पैसे कसे येणार होते, मग ही मिळकत कशी विकणार होतो, मग ती पैसे कसे येणार होते, देण्याची गरज नाही. You need not write. But then you will ask, then if the opposite party will object. If I go on explaining in a court in evidence की मी तयार होतो, माझ्याकडे असे पैसे होते, मी ह्या बँकेत ठेवले ते. No, the pleading is that तू तयार व उत्सुक होता. मग तो कसा होता, काय होता, ते तुम्ही एक्सप्लेन करू शकता. That is not barred because the basic pleading is ready and willing. But here the lawyer's responsibility. मी तयार होतो, मी वादी प्रतिवादीला त्याचे पैसे द्यायला तयार होतो. बरोबर होईल का प्लीडिंग? आणि मग तुम्हाला कोर्टामध्ये तुम्ही म्हणाल की मी तयार होतो आणि उत्सुक होतो. समोरचा वकील म्हणे उत्सुक लिहिलं का याच्यात? तयार लिहिलं, उत्सुक नाही लिहिलं. मग काय फरक आहे? तयार आणि उत्सुक काय फरक आहे? एवढं काय मोठं फरक झालं? मी नाही लिहिलं, एक शब्द तयार होतो असं लिहिलं, उत्सुक होतो असं नाही लिहिलं. काय फरक पडतो? फरक पडतो. Because the law expects that you are ready and willing. What is that? Ready and willing. It is different concept, and that lawyer has to understood these things when you will make a pleading. साधं उदाहरण तुम्हाला. स्विमिंग टँकवर मी पोहण्याला गेलो. स्विमिंगचा कॉस्ट्युम मी घातला. I am ready for swimming. Question is of willingness. मी स्विमिंग टँकवर गेलो, खाली बसलो, पाण्यामध्ये पाय असे हलवत राहिलो, पाण्यामध्ये उडीच नाही मारली. मी रेडी आहे, पण मी विलिंग नाही. ऑलराईट. सो रेडी अँड विलिंग हे जेव्हा कायद्याला अपेक्षित आहे, तेव्हा कायद्याला काय अपेक्षित आहे की मी पैसे देण्यासाठी सक्षम आहे, माझ्याकडे पैसे आहेत आणि ती देण्याची देखील माझी इच्छा आहे, असं वर्तन झालेलं आहे. म्हणून शब्द कसा आला पाहिजे? रेडी अँड विलिंग. मी कॉस्ट्युम घातला, मी गेलो, मी पाण्यात उडी मारली. आय वॉज रेडी अँड विलिंग फॉर स्विमिंग. सिमिलरली आय वॉज रेडी अँड विलिंग फॉर कम्प्लिटिंग द कॉन्ट्रॅक्ट. तयार होतो, कपॅसिटी आहे, पैसे आहेत, बँकेत ठेवलेले आहेत, ते देण्याकरता या दिवशी बोलवला, त्या दिवशी बोलवला, त्या दिवशी बोलवला, असं पत्र पाठवलं, तसं पत्र पाठवलं, तरी तो आला नाही, हे पुरावे देता येईल. सब्जेक्ट टू कंडिशन प्लीडिंग मध्ये हे लिहिलेलं असेल की मी तयार व उत्सुक होतो व आहे. दिस इज द इम्पॉर्टन्स ऑफ द प्लीडिंग. सो युअर प्लीडिंग शुड बी प्रिसाइज. युअर प्लीडिंग शुड बी परफेक्ट. But it should not be lengthy. It should not be incorporating all details of the facts. It should not be repetitive. It should not be scandalous. It should not be of an allegations. And it should be in a precise form. So the pleading. So pleading is defined, first of all, properly in Order 6. Order 6 gives you a general rules of pleading. प्लीडिंग मध्ये काय असलं पाहिजे? ते प्रिसाइज असलं पाहिजे, ते क्लॅरिटीने असलं पाहिजे, डेट असला पाहिजे, इन्सिडेंट असला पाहिजे, सिक्वेन्सने असलं पाहिजे, एकामागे एक इन्सिडेंट आल्या पाहिजे, घटनांचा क्रम समजून सांगितला पाहिजे, तारखांप्रमाणे घटनांचा क्रम आला पाहिजे. दिस शुड बी अ सिक्वेन्स. Order 6 gives you all these rules. Then order 7 takes you to the only plaint. Pleading includes plaint and written statement. Then order 7 only deals with plaint. Then order 8 only deals with written statement. प्लेंट मध्ये काय पाहिजे? रिटर्न स्टेटमेंट मध्ये पाहिजे. प्लेंट मध्ये काय पाहिजे? वर कोर्टाचा जो काय असेल केस, रेग्युलर सिव्हिल सूट नंबर, स्पेशल सिव्हिल सूट नंबर, in the court of civil judge senior division Pune at Pune between so and so XYZ plaintiff name, his age, his occupation, his address, correct address, first address, second address. Then defendants, who are the defendants, who are the necessary parties, who are the uh, possible parties, whatever the parties are there. A precise party should be, unwanted party should not be there, either in a form of plaintiff also, in a form of defendant also. So plaintiff, defendant, then cause title, this is a suit for declaration and injunction. Then coming to the basic parts, the plaintiff prays to the court as follows. A, description, if any property is there, description of the property and the contention relating to the property. 1, 2, 3, 4, 5 grounds. Then important cause of action. On this series of the contentions in the plaint, the cause of action for filing a suit for a specific performance has been arose on such and such date. It is important because it relates to the limitation. From cause of action, the limitation will be counted out. So the cause of action with date, time, and then coming to the limitation. There, because of from the cause of action, the suit is in a limitation. Then the valuation of the suit. Then the relief in the proper form. Designing a relief is a skill of an advocacy, good skill of an advocacy. And if you want to file a suit for an injunction, you can just basically see the injunction law. If it is declaration, see the declaration law. Just write the relief in your own handwriting 1 or 2 or 3 times. Don't go for any draft. First write yourself, verify it, then go to the standard draft. Don't take anybody's computer print. He may be wrong, you will be wrong. So refer book. At any difficulty of the lawyer, his first and utmost teacher is the book, not a senior, not a friend. Don't ask any friend, don't ask any senior, don't telephone anybody. Take the book. Pleading, law of pleading, Bindra, anybody, a standard book, take, see the suit for declaration, what is the relief. Compare that relief with your relief. See what are the suits there, what are the contention there. Then go to the CPC. Find out the format in Appendix A. See that Appendix A format, see that whatever the minimum words are required there are there in your particular plaint. Then see the valuation. Now how the valuation is to be made? Normally the answer is that court fee stamp. Court fee act is there and it describes you the different types of valuation and court fee required on that valuation. No, friends, there is a suit valuation act. In that suit valuation act, how the valuation of the properties are to be made, for that purpose, the valuation market value rules are there. By using the Suits Valuation Act and the market values rules, you have to find out the proper valuation of that particular property. It is a plaintiff who will be at first priority to put the valuation. It will go to the ministerial office. Ministerial office has supervisory power to verify that valuation is correct or wrong, because that valuation first of all relates to jurisdiction. Because if it is 1 lakh rupees, it will go to the civil judge junior division. If it is above 1 lakh rupees, it will go to the senior division. Some places it is 5 lakhs rupees. Some places it may go beyond that. So it is a jurisdiction which is mainly related. Then after jurisdiction, it's a question of making a court fee on that particular valuation. So court fee will be paid on that particular valuation. So this will be verified by the ministerial office. Then the suit will go ahead and the notice will be issued. Again, the defendant will come. Defendant will have a right to object to the valuation that he has shown a 10 lakh rupees valuation. It is not 10 lakh rupees. It is 20 lakhs rupees or 50 lakhs rupees. That valuation can be raised. The court can make an inquiry. The court will believe in such cases on the contention of the plaint, and on the basis of that contention of the plaint, the valuation will be verified by the court. If found more necessary to make an inquiry, inquiry will be contemplated by using the provisions of Suits Valuation Act and the rules made under the Suits Valuation Act for deciding the market value. If required, the help of the Court Fee Act can be taken, and by using all these provisions, court will decide that X, Y is the valuation. You pay the stamp duty if additional stamp duty is required. And therefore, these aspects of a valuation, limitation, cause of action, and relief, designing a relief, is a responsibility of the lawyer. They should understood Order 6, Order 7, Order 8, and by understanding all these things, they should make a proper pleading. So pleading of a plaint and a written statement. If it is a written statement, the contention of the plaint are to be specifically denied. Contention of the plaint number 1, plaint para number 1 is hereby denied. The contention of the plaint number 2, generally all the contentions are denied, is a general allegation and it is not expected. Para-wise denials are expected in a written statement. If any special contentions of the facts are there, such as if a plaintiff says that under this agreement, I make a payment of 25 lakhs rupees to the defendant, and defendant is not agree. So defendant will say that it is wrong to say that plaintiff has made me 25 lakhs rupees as contended in para number 2. Here he will have to make a submission if a payment is made, then how much payment is made. It is contended that the plaintiff has only made a payment of 10 lakh rupees to me and not beyond that. That is a requirement in the written statement. So this is a fight of an adjudication, adversary fight. Yesterday the award sir has taught you that the basic adjudication system. So this aspect of the denials of the facts and specific contentions of the facts should be there. Also thereafter, whatever the defense of the defendant is there, that should be there in this particular form of the written statement. If agreement is there and if he accepts an agreement, and if you don't want to give a specific performance, he has to explain for what purpose this agreement was there. Agreement was there, but it was a document of a security and not a document of a sale and purchase. Likewise, some sort of an explanation to the admitted facts should also come from the side of the defendant. So this is the first phase of the plaint and a written statement. Then comes set off. It's also part of the pleading. If it is a recovery of a money, and if plaintiff says that 20 lakhs rupees is to be recovered from defendant, and defendant denies that, and defendant says that not 25 but 15 lakhs rupees is to be given, then that can be adjusted. The accountment, adjustment, etc. can be done by using the terminology set off mechanism. A counterclaim. Counterclaim is an independent suit itself. And therefore in order 8, rule 6a, the basic rule is that whatever rules of order 7 are there, all are applicable to order 8, 6a for making of a counterclaim. When a defendant, apart from a written statement, makes a counterclaim, that counterclaim is to be designed or drafted or pleaded by using all rules of order 7. So there comes a cause of action, there comes a valuation, there comes a stamp duty, there comes a limitation, and there comes a relief, apart from the contentions. Counterclaim is also a pleading. Counterclaim can be filed along with a written statement. Counterclaim can be filed apart from the written statement if it is within the limitation. Not necessarily it should be only attached to the counter on the written statement. Apart from written statement, counterclaim can be filed. Apart from the written statement, additional written statement can be filed. So this all provision you will get in order 8, and with this order 8, you can go up to the counterclaim. Once the counterclaim is there, the plaintiff is entitled to file a written statement to the counterclaim. So pleadings are completed. Plaint, written statement, counterclaim, and written statement to the counterclaim. So 2 documents of plaintiff, 2 documents of the defendant. So this is in totality a pleading before which the suit stands. On the footing of this pleading, suit will stand. All evidence, documentary or oral, any other activity whatsoever nature, should be on the basis of this pleading only and not beyond this pleading. Anything beyond pleading is irrelevant, will not be considered, will be thrown away by the judge. That should be a basic concept in the mind of an advocate. So pleading, many times a question is asked that an interim application for an injunction is filed. Interim injunction is filed. Exhibit 5 we call in the district courts, or notice to motion in the original site, or even maybe in a small cause court. That procedure may be there of a notice of motion like that, where some interim relief has been claimed by the plaintiff or a defendant. So the contention in that application, whether it is a pleading or not, this question comes. And for that purpose, many times I found that confusion occurs, because it is also the prayer, there is also prayer, there also an independent stamp is affixed. But in a main suit, it is a in-between activity, interim application. It is not a pleading, because the definition of a pleading in order 6 is that plaint and written statement. And counterclaim is a plaint as per order 8(6)(a). Therefore, it is again a plaint. And there is a written statement to that plaint. So basically, pleading means plaint and written statement. No any other application, no any other petition, no any other contentions. So whatever the contentions are before the court in the form of a plaint or a written statement, they are only the basis of the pleading, not anything else. So friends, this is the something which I want to put before you on a point of the pleading. Now, amendment of the pleading. What is this amendment? It is frequently used concept, and also it is interesting one. Amendment is a right to make certain corrections, or amendment is also to inform certain subsequent developments, and therefore amendment as of rights are given if it is in a plaint or a written statement. What should be the basic concept of the amendment? Basic concept of the amendment is that it should not exceed the subject matter of the suit. The amendment should not exceed the subject matter of the suit. If it is an amendment in a plaint, it should not exceed the basic contentions in the plaint. It should not change the nature of the suit itself. If it is written statement, it should not change the defense taken by the defendant in a written statement. So the basic concept of the pleading should not be changed is the basic rule of an amendment. Here I want to share very interesting case, and it's not related to the CPC, it is related to the Constitution. And young lawyers like you are well acquainted with such cases, because they are the famous cases which are taught in the law colleges. The case is of Keshavananda Bharati. You know that Keshavananda Bharati, 13 judges, the historical case in the history of Indian judiciary, pronounce a judgment concerned to the amendment of the constitution in the case of Keshavananda Bharati. Very interesting history is there. There were 13 judges. The matter was referred whether the amendment of whether the uh, parliament has a power to amend the constitution. And if a power is there, to what extent that power can go. The word was amendment of the constitution. 6 judges decided that the parliament has all powers because the parliament are the makers of the constitution, and parliament has made this constitution. They can make any changes in that constitution because they are the author of the constitution. So they had all power to make the amendment in the constitution. Article 368 of the constitution. The 6 judges decided that no, you can't make any change. You don't have power. It was that Constituent Assembly on 26 November 1949 which adopted the constitution, and thereafter the parliament which was established subsequently do not have any power to make any amendment in that constitution, and therefore there is no power. So 6 versus 6 was the dispute. Here comes the 13th judge, and he was Justice, the great jurist of this country, who must be saluted at all times, Justice H.R. Khanna. So he was a 13th judge. He neither agreed this view, neither agreed that view. But he proposed a very innovative concept. He said that what we are dealing with, friends, we are all discussing all these things. We are discussing an amendment of the constitution. And therefore, we should see the grammatical meaning of the word amendment. And that grammatical word of an amendment is that making change in an existing thing, basic thing. Whichever is the basic thing, making change without changing entirely. So he made a proposition that we can make an amendment, but we can't change the nature of basic structure of the constitution. He made an example. Suppose a suit is there and suit amendment is to be made. Then entirely suit cannot be replaced. Whatever basic subject matter of that suit is there, whatever nature of that suit is there, keeping that basic nature intact, you can make certain changes which are consequential to that particular pleadings, which are not opposed to that particular pleading, basic pleadings. And therefore he said that constitution can be amended, but it can be amended only by maintaining a basic structure of the constitution. And you know the famous things, basic structure, which he has explained, that the non-religious nature is the basic structure, the parliament 5 years election is the basic structure, maintaining judiciary is the basic structure. So many things he inaugurated in that Keshavananda Bharati's case. So friends, here also, when we are talking of an amendment, that basic concept of the word amendment must be there in a mind. Either you are amending a plaint or you are amending the written statement. So the basic structure of the suit or the written statement, the basic defense there, basic contention there should not be changed. Accordingly, you can make an amendment. So this is the something about the amendment, friends. So the another important aspect of the matter is the service of the summons. Once the pleadings are there, once properly valued suit comes to the court, then 2 aspects must be learned by the advocate. Before summons, I will like to take an important aspect of the jurisdiction. Section 9 deals with the jurisdiction, friends. And jurisdiction, one should be very clear in a mind that all disputes are always within the jurisdiction of the civil code unless expressly or impliedly barred. All disputes are covered by civil courts except that disputes which are expressly or impliedly barred. Now, what is expressly barred? You can understand. A express provision of a law is there. Any law, you can take any law and you will find many. Suppose nowadays the youngsters are dealing with a DRT, a bank dispute is there, and DRT Act bars the dispute to be referred to civil code if the jurisdiction, if the valuation is above 10 lakhs. So there is an express bar in that act. If anything relating to the service matter is there, MAT is there, CAT is there. So the jurisdiction of the civil code is expressly barred. If it is a agriculture tenancy act relating to the agriculture tenant, then in that particular manner, the jurisdiction of that dispute is given to the Mamladar, the Sildar, and in SDO, and he can have a jurisdiction. You have to go to that dispute, and your civil code jurisdiction is barred. So there is a section in that particular law relating to that particular subject which says that civil code jurisdiction is barred. This is express bar. What is implied bar? Implied means indirect, indirect bar. For that purpose, we'll take two examples. One example, suppose, of getting an NA order from the government. Another example, for getting a building permission from the town planning act, town planning authority. Suppose we go for the NA permission, and if NA permission is refused, can you file a suit against the government by giving a Section 80 notice saying that the order is not proper? There is no such a bar in a land revenue code that don't go to the civil code. But there is a complete mechanism given for challenging that order. If NA is not given by the collector, you can file a appeal or revision to the commissioner, or you can go to the government, or you can go to the another authority. And therefore, there is a complete mechanism to challenge the order of the collector or deputy collector, whoever is there, for non-granting a NA permission. Secondly, if it is a regional town planning act, in a town planning act regarding plan, don't go to the civil code is not an express bar. But there is a complete mechanism which is there. If a building permission is not given by the town planning authority, you can go to the joint town planner, where you can make an appeal. From there, you can go to the director town planning. From there, you can go to the government. So this mechanism is already there. So where an independent, complete mechanism for adjudication of that dispute is already provided, that you can't bring to the civil code. It may be then labor disputes, it may be then cooperative dispute. In a cooperative, in fact, there is an express bar. Cooperative law says that the matter which are touching to the business of the society need not be brought to the civil code. Civil code jurisdiction will be barred. It should go only to the cooperative code. But there are certain these types of various activities in our day-to-day happening, such as the town planning, such as the NA orders, many other things, where a specific mechanism is provided. It may be a land record office, the land record appeals are there. It may be some other, these are all civil disputes. But these civil disputes, they are having a mechanism to challenge that particular authorities at this particular different types of forums. And therefore, these jurisdictions are impliedly barred. They can be said to be impliedly barred. And therefore, this particular concept is of no importance. So this is the concept of the jurisdiction. Summons, I will only say that go the provisions of summons. Rule 1 to 30 are there. Also read 27, 28, 29, 31, 32 sections. And you will find that three types of the summons procedures are there. First is the personal service, which is mandatory. You can't bypass that. A summons through code to be served through bailiff. This is the direct summons authority, and you have to first exercise the all possibility of making this service. Then only you can go to the other mode. Then one is a substituted service. What is that? Repeatedly the service is not summons. Then you can make a substituted service by affixing the summons on the door of the house of the defendant. Or you can have a substituted service of making a public notice. You can have a substituted service of Order 5, Rule 17 of throwing the summons on the body of the defendant. These types of different types of service of summons, they are called as a substituted services. And the one thing is often alternate services, which can be used at a time. What is that alternate? By summons by register post, summons sending by authorized courier if the couriers are approved by the High Court in that particular area, summons through fax, summons even today. Now the WhatsApp, in at least in a matrimonial matters, on a WhatsApp the summons service is accepted if that all green and red buttons are available. So these all alternative digital type of the service of the summons, they are covered in the alternative form. Now it's in fact a time where these alternative modes should be incorporated in a form of the first part also. And apart, along with the personal service, one service should be there for the legality through the belief. Now you must be coming across the new development in this area, as Justice R.C. Chavan was yesterday there. Now the different machines are going to be delivered to the every belief so as to track his route, where really he has gone and whether he has really gone to the house of the defendant and has made that particular service properly or not. That is going to be checked. Even the house, whether it was really closed or some false report is made, a photo will be there and everything will be tracked available with the court on the computers. This new mechanism is going to have, but many times the service, personal service, depends on the integrity of the belief itself, and therefore this is delayed. And the major time of delaying the civil trial, whatever assessment at least I have made, 35% of the time is wasted for this service of the summons. And if you can curtail this time and make the early service of the summons a proper service of the summons, then the suit will be expeditiously heard and they will be decided not more than 1 year by using all the provisions of the CPC. So service of the summons is an important aspect. Friends, here I want to impress you the one important provision. See, the suit is filed, the defendant appears, he files a written statement. And after that, normally the impression is that now the issues will be framed. Here, two things are missing. First of all, this particular procedure of filing a suit up to the written statement is completed from Order 1 to Order 9 of the CPC. See, 1, 2, 3, 4. Order 1, party, who are the parties? 2, 3, the recognized agent, where it is to be filed. 4, the place of filing the suit. 1, 2, 3, 4 deals with the suit and its filing, first part of the suit. Then summons is issued. Order 5 deals with summons. What are the pleadings? They are explained by Order 6, 7, and 8. In Order 8 and Order 9, defendant role comes into picture. Defendant appears and he files a written statement or he files a counterclaim. So from Order 1 to 9 particularly, a major part of the pleading is covered. Now Order 10 comes into picture. And I want to impress on all the participant young advocates that carefully read Order 10. It is not used many times. Order 10 is a provision where court is given a responsibility to find out from pleadings, that is a plaint and a written statement, which facts pleaded in a plaint are admitted in a written statement and which facts pleaded in a plaint are denied in written statement. These admitted and denied facts are to be recorded on Exhibit 1, that is suit, by the court. That is a mandate of Order 10, Rule 1. And in a practice, we forget this. We all, including ourselves. In fact, if this provision is used, then the suit becomes very short. We have to lead the evidence on the disputed facts. The facts which are admitted need not be proved. That is the jurisprudence which we have learned in an evidence also. The facts which are admitted need not be proved. If in a suit for a specific performance it is admitted that agreement is there, but agreement dispute is that whether it is sale purchase or whether it is a security document. So the issue of execution of agreement did not be proved. Many times we find that the time is wasted on proving this particular aspect, whether agreement is executed, not executed, whether it's proper, not proper. So order 10 gives you this power. Beyond that, order 10 gives a provision for calling the advocates, calling the parties, calling some documents, calling some witnesses, so as to assert out of this dispute which part is admitted and which part is disputed. So this can be done in order 10. So it is important, friends. Perhaps I will say that this is to be treated as a first stage for hearing, and it should be properly used by the advocates. It is a responsibility of the advocate. They should use these provisions. Many times in a clip, we propagate order 10 and the advocates have given an applications in the courts. Court said that हे काय भाव आता नवीनच पुन्हा लांबवता तुम्ही. Then you have to read the order 10. Many our club participants called me at that time. I said that you go and read that and tell the court that it is your responsibility, sir. I am helping you. Because the wording used in Rule 1 of Order 10 is that after receipt of the pleading, the court shall record the admitted facts and the disputed facts on Exhibit 1, and therefore it is your responsibility. I have put an application. If you want to fulfill your responsibility, do it. Otherwise, pass an order that I am not doing it. It will go on. Advocate should do his own role, of course, legally by putting an application. And whenever you are putting any application, keep a point in your mind that try to put some provision there. This is an application under 10 Rule 1 for admission and denial of the facts. And then start writing your application. By writing such a provision, you will be impressing 50% more to the courts that yes, you are well versed with the provision or you have at least read. You may be wrong on that provision. Putting a wrong provision is not something very serious thing. It can be always corrected. Court are sitting for that. Lawyer will propagate something, law also, facts also, the case laws also. Court has to ultimately appreciate. You have to assist to the court. We are the law officer assisting to the court, and therefore one should do our duty. So order 10 is important. Also in the form of an ADR. 89 can come at any stage because 89 word for ADR, use of an ADR is that at any stage of a suit, if court finds that there is an element of a compromise, then court can ask for ADR. But in order 10, rule A says that after receipt of the pleading only, the court should go for this ADR. They should ask for the arbitration, they should ask for the mediation, they should ask for the conciliation, they should ask for the other forms of the ADR mechanism. Here, friends, this is new area where you will have to work now. ADR. It is a requirement of the time. We must support it. But we should understand what is that. It should be a question of a different lecture only. We can have a different lecture on ADR mechanism. But friends, briefly, arbitration, it's just a replacement of an adjudication from court to some private party. So it is controlled by Arbitration and Conciliation Act. Conciliation is also controlled by Arbitration and Conciliation Act. Mediation is not controlled by any law. It is controlled by the rules framed under the Civil Procedure Code. You will find that there are mediation rules, and as per that mediation rules, the activity of the mediation is controlled. And Lok Adalat, which is controlled by the Legal Services Authority Act. So these are the different forms of the mechanism. You can understand Lok Adalat, panel seats, arbitration, the evidence is laid. You can put certain documents and conduct speedy trial. The difference between the conciliation and a mediation is most of the time misunderstood. What is the difference? Conciliator and a mediator. A simple first important difference is that mediator is a neutral person. He will not participate in a dispute. He will give hearing to A party. He will communicate that hearing to B party. He will give hearing to B party, that he will communicate neutrally to A party. A and B will interact. They will interact themselves. Mediator will not make any suggestions. He will remain neutral. And out of that, their interactions, it may happen that real dispute will come on the floor. You know that many times in a dispute of an husband and wife, we file a suit for divorce, but actually wife wants maintenance, or we file a suit for maintenance. Many times the wife wants divorce, or husband-wife, the husband wants a divorce. So real controversy by personal interaction should come before us, because whatever will be interacted, spoken, written, will be not a part of the evidence. It will be kept away as per the provisions of the rules. And therefore, the mediation is the neutral person, mediator is a neutral person. That is not a case of a conciliator. Conciliator can participate, he can suggest, he can mold the settlements, he can make the dialogues independently, and everything can be done. He is not a neutral person. So the basic difference is that conciliator is not a neutral person. He will participate entirely in a dispute. Mediator is the neutral person. So this concept should be there when you will use this ADR mechanism. And particularly, I will impress that as far as possible, try to put order 10 in use, and that should be after receipt of the written statement, you should go for the ADR mechanism. So friends, now near about my time is completed, and I hope that we should not take much of the time of all of you participants. But lastly, this discovery and inspection part, I must tell something to you. Read carefully. Order 11 is there. Order 11 talks about rule 1 to 10 about the interrogatories. It's a written question and answers. Questions to be given by one party and written answers to be given by another party before hearing. Which questions are to be admitted and which questions are not to be admitted is the power of the court. The plaintiff may give 20 questions. The court may approve 10 questions. That 10 questions will be served on defendant. Defendant will have to answer that questions. If defendant don't answer that question, plaintiff will again make an application and demand court to direct him to answer. Court will again direct him to answer that questions. And if that questions are not answered thereafter also, the adverse inference will be drawn against the defendant for non-answering that particular questions. That will be a serious thing against him when the evidence will be there. So interrogatory is important. It can be given by plaintiff also. It can be given by defendant also. Once in a suit by one party. That is a liberty, unless some special reasons are made out, and that has been put in writing and some leave has been taken from the court. This is the something interrogatory instrument, very good instrument in the hands of the parties there. Then there is an inspection of a document. Documents on which the plaintiff pleads and relies, pleadings are there, and relying is there, then in that particular document, it should be filed along with the plaint. Defendant, when he is relying for his written statement, pleading in a written statement on some of the document, that document must be placed on record or submitted to court along with the written statement. That is the basic rule. If that is not done, here either party can ask for an inspection of that documents. And that inspection can be given, particularly for the document referred in a pleading. Necessarily, the inspection can be given. It can be given, inspection can be obtained in the court, in the office of the advocate also, in the courts also. From inspection, you can take a certified copies. They are permissible. and they can be placed on record also. So inspection is the another mode. Then there is a notice to produce. Notice to produce document. Notice to produce document by party. Notice to produce document by not party, other person than party. That notice to produce instrument is available under order 11. Then there is notice to admit. That notice to admit can be made is available in order 12. Rule 1 to 12 is there, and you can use that. 1 to 8 is there, and you can use that notice to admit. Notice to admit particular fact can be given. Notice to admit particular document can be given. It can be given one time, it can be given many times, as and when required. So these are the instruments, friends, in the hands of the parties, either plaintiff or defendant, and they can use it and make the length of the suit short. See, a suit is there, plaint is there, written statement is there. You are using order 10. Certain admitted fact, disputed facts are clear. Admitted facts are recorded. The length of that admitted fact is gone now. You don't have to prove this. Then you are using order 11 interrogatory. Some facts are already clarified. You are using notice to admit. You are using the documents. And this length is there. This much length is gone. Evidence, your burden of this much evidence is gone. And you will have a burden of a short. So this short burden is a skillful advocacy, friends. How to do the short burden in a witness box upon my party? That is an architectural design by an advocate based on the Evidence Act, based on the Civil Procedure Code for conducting a civil trial. Your design must be ready. What I am going to do. Don't go vague. Many times we just lift the brief, we read it, then we go on recording evidence, go on pleading, then argument comes, and before argument we try to find out some law. But before that, if your entire suit is designed, yes, I'm going to plead this, I'm going to use this particular provisions, I'm going to use interrogatories, I'm going to give a notice to produce this. So your entire design can be made. You are architecture of your own suit. And you have to design accordingly. Accordingly, if you are a defendant, how to defend it, you have to make your own architecture. The judge is there. In this entire drama, he is your director, having all authorities. But in that authority, your skills of using provisions, proper track, proper procedure, fairness, bona fideness will make the director pleased in your favor. So ultimately, it is not a favor which you are demanding from the judge. You are traveling on a correct path shown by the CPC, path shown by the Evidence Act, path shown by the other laws with which you are dealing with. And with that, friends, if you travel your that entire trial, your entire that episode is impressed by judge, by opponent, by the audience, by the seniors, everybody. When lawyers start working on this technically, procedurally correct procedures, the other mob who is looking behind you is impressed, friends. And that is the success key for your good advocacy. When you will get one client who was opponent in your some matter, and when he will come to you to represent his another cause, that is the point of, that is first symbol of your success, friends. That some opponent for against whom you have contested in some other matter, he appreciated your work and he came to you for your assistance in his some different matter. This is possible if you work scientifically, if you work patiently, by making a shouts, by making an arrogant approaches, by showing a fights, maybe popular things. But personally, my own perception is that that don't pay for a long time. You may please somebody for some time, but not an always. And therefore, whenever you are conducting a civil trial, try to use a correct procedure of a correct stage. What is a correct stage, or what is a stage? And for this particular stage, what is a correct procedure? This must be known to you, or this much only should be known to you. Not all provision. You need not have सगळ्या पाठ करायची गरज नाहीये. 158 सेक्शन पाठ पाहिजे का? नाही. 108 ऑर्डर 51 पाठ पाहिजे का? नाही. सगळं प्लेडिंग पाठ पाहिजे का? नाही. समन्स, पर्टिक्युलर टाइप्स ऑफ समन्स बजावला जात नाहीये. रुटीन समन्स तर कोर्ट पाठवणार आहे, त्याला तुम्हाला काय करायचंय? प्रोसेस लावली का पाठवणार आहे. पाठवल्यानंतर तो बजावला जात नाही, त्या सर्कमस्टन्सेसमध्ये कोणती प्रोव्हिजन तुम्हाला युजफुल करू शकतो, त्याची करता ऑर्डर 5 वाचावी लागेल, मॅन्युअलचा कोणता पॅरा वाचावा लागेल, सेक्शन कोणता वाचावा लागेल, ते महत्वाचं आहे. डोंट जम्प ऑन अ केस लॉज. केस लॉज, they are outcomes of the facts, different facts. And therefore, nowadays there is a fashion in a judiciary also. The case laws are quoted and simple line is written there that these case laws are not applicable to the facts of the present case. Simple line is there. बरोबर ना गाडगे साहेब? So simple appreciation by the judges are there. 10 cases. Okay, all these I have gone through these cases, and these cases are not applicable to the current facts. This is over. So don't use it. Case laws are not bad. I'm not against the case laws. But so many provisions are there in the CPC, CRPC, Evidence Act, which can be appropriately quoted. And on that particular aspect, when elaboration is required, you can go for a case laws. You can find out the case laws. And that case laws can be there. As per my own appreciation, for 99.99 procedural aspect, the provisions are sufficient. And therefore, you should use it. Only one topic remains, and that is of a High Court amendments. So now it's 2 past 10, I think, and with Chairman 1 past 10, Chairman. So I will not exceed now. I will stop here. If of course any live questions, 1, 2, 3, 4 questions are there, and if you are permitting, I am ready. But High Court amendment remains. Whenever, either in this course or in some other part, whenever possible, we will discuss these High Court amendments. They are important and they are to be looked. But only one appeal will be there. Whenever you will purchase the book of the Civil Procedure Code, try to take the Bombay publications. Don't go for other state publications. Other state publication will be with their High Court's amendments. So try to publish the Bombay High Court amendments. See that the Bombay High Court amendments are incorporated in CPC and CRPC particularly. And therefore, my appeal will be that you should try that. Also, I will make one appeal. There is a book on a civil procedure code by C.K. Takwani. Honorable C.K. Takwani is a former Chief Justice of a Bombay High Court. His name as a Chief Justice is Justice C.K. Thakkar. When he was a Chief Justice for a long time, a great academician, he has written many good books. On a CPC, a book published by the Eastern Book Company, C.K. Takwani is the name. He is not writing the books under his name C.K. Thakkar, but he writes a book under name C.K. Takwani. And his book on a CPC, 28th edition is there. Eastern Book Company is the publisher. Try to purchase that book. It will be very used. It is a student edition, but still it is a fantastic book, and it will make your all burden of the CPC very, very easy. So with this, I am thankful to Honorable Chairman and all my colleagues on the Bar Council for giving me this opportunity. I am thankful to all the participants, and I am again making an appeal that friends also tell to your other colleagues, because I'm looking that near about 671 participants are there, very big number, good number. Congratulations to them also. Congratulations to all my coordinators of the club, and also the staff of the Bar Council Secretary and Mr. Bagul. I'm thankful to you. But tell the others also that it's not only the question of compulsion. It's a process of making you good lawyer. For that purpose, this BLEP, Basic Legal Education Program, has been designed by the Bar Council, and in a coming time, you should participate it with without considering that only compulsion is there. Compulsion is there because the rules are made now. The resolution is there, and everybody will have to take a certificate from the bar council that you have completed this particular part, and therefore it's not for compulsion. I'm not sitting here for you for 2.5 hours out of some compassion. It's my own desire that you should be shared with our experience. And also, the Honorable Chairman has requested many other good speakers who will be participating in this entire program. So it's sharing, friends. And by making such type of a sharing, such type of a dialogue only, we can develop our knowledge. We can continuously go on learning this process because it's a continuous learning process. Still, I know few things of the CPC. I don't know everything of the CPC. I am also a student.
10 मिनिटं
Thank
10
you,
मिनिटं
and thank you therefore participating.
Sir, we have some questions.
Yes,
And first question is, like you have suggested a good book for CPC. Can you please suggest some book to learn feeding and drafting?
reading and drafting. Bindra's book is good. Old book. It's a good precise reading.
Okay,
Author's
sir.
name is Bindra. It is famous drafting pleading book. So you can go for that book.
Okay, sir. Another question, sir. Is the process fee exempted as per the Bombay High Court process fee rules?
For what?
Process fee, when we file a suit, process fee, have you
No, no.
stated?
Process is to be affixed.
Okay, sir. Sir, can you please explain res judicata, concept of res judicata in short?
Actually, res judicata means when on a same between the same parties on a same subject matter, already the adjudication is completed in some another proceedings, and once that particular proceeding has been completed, another again there cannot be a new adjudication. But I am keeping this some of the concept along with the Bombay High Court, and we'll discuss in detail in at that time because the wrong impression should not go with them.
Okay, thank you, sir.
Yes. Any more questions?
Sir, there are a lot of questions, but again, sir, it's more repetitive in nature, sir.
Oh,
Sir, abatement of suit. One question regarding abatement of suit.
abatement means if the plaintiff is not taking the legal heirs of the defendant in time, 90 days time, from getting the knowledge of the death of the defendant, then suit stands abated. That is the basic thing. Means it's a responsibility of the plaintiff to bring the legal heirs of a defendant in time. Of course, the starting point is knowledge of that death. And once he got the knowledge, then from that particular time, in the 90 days time, he has to bring the legal heirs. And if he is not bringing that legal heirs, then suit stands abated.
I think, sir, that's enough, sir. And sir, one more request from my end, sir. What
Yes,
you have
please.
taught us, you please impart upon the participants that whenever an application is made, a section to be rated. You skip
Yes,
that
sir.
part, sir.
I will against concluding while this lecture, I will make that appeal, make an appeal to all of the participant friends that whenever you are making any application in any court, whether it is a civil court, criminal court, or any other tribunal, try to mention some section, whichever is relevant there, and put any rule which you know. And that is possible when you can just make a research. So it's helpful two ways. You make a research in advance, and secondly, even the courts are impressed because of that particular drafting. So try to do that.
Pawar, sir, can you please express vote of thanks, sir? Kazi, madam, Shabna, madam.